Happy Friday, everybody. Kimberly Doyle. If you're still out there listening somewhere or employed with WorkplaceNL, let's have a discussion about you today, okay? So, back in 2019, when Dustin had a reoccurrence in Fort McMurray, Alberta, for 7 weeks, you did everything to try to deny him his compensation. You told him, though, that all he needed to prove was that it was the same body part and same symptoms, which he told you he had. He told the medical doctors that he had, yet you tried to say he worked the day before, which, in my opinion, was you trying to turn it into something that happened at work the day before, when he didn't do anything to cause that reoccurrence. It just happened because it was a permanent injury that was not diagnosed properly on January 10th of 2018, which the medical facts all state. It was not diagnosed. It was just an assumed diagnosis, and everything went from there. Now, instead of focusing on the facts, and instead of focusing on the unfair results, and instead of focusing on what loss of earning capacity really is and how your decision to focus on denying him was going to cause extremely unfair results that you would be guilty of causing, we did end up with a lot of unfair results. And you caused a loss of earning capacity to Dustin that was of the utmost extreme that any injured worker could be forced into because of a decision from an employee like you. Why? Because you forced us from Fort McMurray, Alberta, to rural Newfoundland. The earning capacity in Fort McMurray was extremely a lot higher than what it was in Newfoundland, Labrador, and rural areas. Why? Because access to jobs was more readily accessible if you had allowed him to stay here and compensated him to ensure he was able to stay here. Then, when we went back to Newfoundland, Labrador, and we had to live where we had to live because we could not afford a place to live in Corner Brook or St. John's where jobs were more accessible. Not saying that they were accessible enough for him to get a job there, because we can prove as well that all of his jobs in Newfoundland, Labrador were in more rural areas and secluded areas where fish plants were. So that would have reduced his early and safe return to work that he needed, which the medical can prove once he went back to work with Sanatni Seafoods, because when he was no longer getting his physio and chiro, he ended up back on a cane and having to go back and forth to Corner Brook to get his chiropractic treatments on his days off, which would not have happened had the employees had the conversation about what a safe return to work would look like for him and include the medical documentation that even their own medical consultants had provided with them. So, Kimberly Doyle, yeah, you are a bully, you are a liar, you did not pay attention to the facts, you were not worried about the medical information that was put forward to you, you were not worried about a safe return to work, which I may have already said about that, I'm not sure. But yeah, safe return to work is also a huge thing that you impacted. Because had he stayed here in Fort McMurray, he would have had better access to jobs, better access to jobs that would put him in a safer situation when he returned to work. It would have been better for his early and safe return to work because he would have had access to all the same chiro and physio support as he did not have in Newfoundland Labrador, living 4 hours to 4.5 hours away from his physio and chiro. There's a lot of things that your decision negatively impact Kimberly Doyle. And these are the conversations that I'm very annoyed with that never happened. Never, never, never happened. And as a management of his claim, these are important discussions that you guys should have had, that you did not. Not in one instant does any of that file cover any of this. It was just all about you. Every decision in his file is all about what's better for your bottom line. Not what's better for Dustin, not what's better for his financial situation or his safe return to work or his ability to get work. Nothing. There is a lot of lies about obligation to return to work, a lot of manipulation in there. There is a lot to prove you guys guilty. You don't have a legal leg to stand on in a court of law, and the actual decisions that you made don't belong in a court of law anyway. The Act states that once you guys are aware of this, you need to pay immediately plus interest because it's all of your fault. So don't tell me that you follow the Act because you don't. I've sent you the proof many times. Yeah, sometimes there's a rant in between. Most times maybe, but still, you should be smart enough to be able to read between the lines and do what you need to do, but you haven't. And you haven't had the conversation. You've shut down all lines of communication. So that shows that you're not even willing to discuss as mature adults what you've done. And neither is the Human Resources Department, because for some reason, protecting your employed behind is more important than actually holding you accountable for all the harm that you've caused, which is wrong. But this doesn't belong in a court of law. It belongs in the Human Resources Department. That's where it belongs. It belongs in the superintendent and the director's departments. Like Sherry. She should also be involved in this discussion. She should also be reaching out right now and getting this all started. But is she? No, she's not. So she should be hauled into human resources as well. Why are these people not being held accountable by their employer for incompetence? Why? And why is the news not interested?